some of the most public and well-known issues that have been labeled as cybercrime, what does really cybercrime mean? We asked several people from all over the UP campus and asked them what they think cybercrime is. Here is Miss Cavilla for some updates.
Meron akong kwento!
Ano yan?
Halina't pakinggan ninyo!
Kuya, ano po sa tingin mo ang cybercrime?
Hindi ko nga alam yun eh.
Yeah.
I think yung cybercrime kasi parang big issue siya kasi first and foremost, pinag-uusapan ko is yung things about libel.
Hindi sa cybercrime.
Ay, hindi ko alam kung ano talagang pakay nila dyan eh. Ibang bata lang para tayo.
Yung sinasabi nila na parang masyado daw o offensive yung mga
Sa tingin ko masama siya.
pag sina-cyberbully ka kasi, dinedegrade nila yung pagkatao. Dinedegrade ka, parang malaking issue yun sa pagkatao mo. And it's a human right. So, I'm totally against cybercrimes.
Sa tingin mo ba nag-commit ka na ng cybercrime o cyberbullying?
Yes. To be honest, I have, although I am against the I tend to do them kasi hindi ko napapansin.
Cybercrime parang yung paggamit ng technology such as internet to commit acts such as infringement of copyright or basically just stealing using the internet.
Thank you! Back to you, Jo Marie.
Are these opinions entailing the true meaning of what cybercrime is? Maybe we should ask someone for a concrete definition. RA number 10175 is also known as the Cybercrime Prevention Act of 2012. We talk about measures to protect Filipino from cybercrimes, and we're talking about online theft, fraud, hacking, cyberspotting, cybersex, and child pornography that deals with a wide spectrum of crimes that could be committed online. Regarding held in Metro Manila on Monday, the 25th day of July 2011, it goes without saying that this law has its own share of supporters, and the main author is Senator Edgardo J. Angara. Divided into 31 sections spanning 8 chapters, the Act penalizes various types of offenses, including illegal access, data interference, device misuse, cyberspotting, computer fraud, cybersex, and spam, and other offenses. It also acknowledges the Anti-Child Pornography Act of 2009 and also penalizes libel when committed using the cyberspace. The Regional Trial Court shall have jurisdiction over any violation committed by a Filipino national regardless of the place of commission. Jurisdiction shall lie if any of the elements is committed within the Philippines or committed with the use of any computer system wholly or partly situated in the country, or when, by such commission, any damage is caused to a natural or juridical person who, at the time of the offense was committed, was in the Philippines. In comparison with the controversial Stop Online Piracy Act (SOPA) proposed in the U.S. Congress late last year, the Cybercrime Prevention Act will actually be similar to SOPA, aiming to prevent cybercrimes here in the Philippines. However, it is also far worse than SOPA because teenagers or anyone else who posts a libelous Facebook comment may face a maximum prison term of 12 years and a fine of 1 million pesos.
Firstly, we agree that the Philippines does need an anti-cybercrime law. However, we believe that the anti-cybercrime law in its current form can still be improved. At this point, we will be discussing several sections of the anti-cybercrime law that we believe should be amended. Let's get started.
According to RA 10175, cybersex is defined as the willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious exhibition of sexual organs or sexual activity with the aid of computer systems for favor or consideration. As you can see, the definition itself is very self-explanatory. Firstly, we would like to say that we do not deny that abuses can and do in fact arise with regards to cybersex. Examples of some of these abuses include the maltreatment and the exploitation of women in cyber prostitution ring. That said, the issue arising from cybersex is a moral one. Should two consenting adults be allowed to engage in cybersex? A particular example would be an OFW and his or her spouse. Given that these two people are separated by a great distance, connected only via the internet, should they be disallowed from performing cybersex? Based on that example, we believe that a cybersex provision can be seen as a violation of the rights of two consensual parties. Thus, we propose that this provision should be redefined to target specific abuses, such as violence, maltreatment, and exploitation, so as not to infringe on the rights of people. Next we have the controversial libel clause. According to RA 10175, the unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code as amended, committed through a computer system or any other similar means which may be devised in the future. How is libel defined then? Based on Article 353 of the Revised Penal Code. Definition of libel. A libel is public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. As an example, tweeting or posting on Facebook that Senator Soto is a or that he is a or even that he is a can be considered as grounds for cyber libel. Now here comes the important question. Does this provision violate the right to free speech? Many argue that it does in fact infringe on people's right to free speech. There are some, however, in particular those who have suffered from so-called cyberbullying, like Senator Soto, who support this provision. We won't deny that words can be damaging to both a person's mental health as well as his or her reputation. However, does this mean that people should not be allowed to express negative opinions about others? As it is currently worded, virtually any negative remark would be argued as libelous. Also, because aiding or abetting a cybercrime is punishable, simply liking a libelous Facebook post is a crime. Therefore, we propose that this provision should be redefined or even removed entirely in order to protect the rights of free speech of the people. Next we have Section 6, which states, all crimes defined and penalized by the Revised Penal Code as amended, and in special laws if committed by, through and with the use of information and communications technologies, shall be covered by the relevant provisions of this Act, provided that the penalty to be imposed shall be 1 degree higher than that provided for the Revised Penal Code, as amended in special laws as the case may be. What this implies is that any crime done using a computer is worse than actually doing it in real life. Thus, crimes using a computer should be punished more harshly. Is online identity theft worse than real-life identity theft? Should it have a corresponding higher penalty? We disagree. Crimes done using a computer are not necessarily worse than crimes done in real life. Hence, we propose for this section to be changed such that the corresponding penalties are not 1 degree higher than those specified by the Revised Penal Code. This section is actually quite long, so let's just focus on the relevant part. Law enforcement authorities, with due cause, shall be authorized to collect or record, by technical or electronic means, traffic data in real time, associated with specified communications transmitted by means of a computer system. What constitutes due cause? Two parties will not always agree on what due cause is, and thus, given its lack of definition here, it is open to various interpretations. As it currently is, it can essentially give government any reason to collect a person's data. It also does not require authorities to secure a warrant, which opens it up further to abuse. Consequently, we propose two things. First, that the term due cause be thoroughly defined in order to better protect the people's right to privacy. And second, adding the requirement of having secured a warrant from the courts before any collection of data can take place. This section is also quite long, but here is the most important part. Within the time period specified in the warrant to conduct interception, as defined in this Act, and A. To secure a computer system or a computer data storage medium. B. To make and retain a copy of those computer data secured. C. To maintain the integrity of the relevant stored computer data. D. To conduct forensic analysis or examination of the computer data storage medium. And E. To render inaccessible or remove those computer data in the accessed computer or computer and communications network. What this basically means is that the government can take and destroy not just your data, but the actual machine as well. We feel that such a provision is extreme in the sense that not only can people lose important and sensitive information, but also lose expensive hardware investments. We propose that instead of allowing the government to destroy data in the actual hardware, these things should be returned in the event that no findings are found after the investigation. Next is Section 19, which states that when a computer data is prima facie found to be in violation of the provisions of this Act, the DOJ shall issue an order to restrict or block access to such computer data. Prima facie is a Latin expression meaning at first sight, or at first appearance. Basically, this section gives the DOJ the power to block access to computer data, which also includes access to websites, all at first glance, meaning without any prior notice or official review. We feel that such a provision is unjust, as it violates the rights of the people to due process. It effectively gives the government total control of the internet in the Philippines. That said, it is arguable that such a provision is unconstitutional. Therefore, we propose that this section be scrapped or rewritten to account for due process. This ends our discussion of the possible amendments to the Anti-Cybercrime Law. For more information on the Anti-Cybercrime Law, be sure to check out the actual document at the following website.
Girls come snapping at me.